My name is Sonia McKenzie, and I serve as General Counsel for the Cherry Creek School District. So I assist your staff and administrators in answering and resolving whatever legal dilemmas they find themselves in. And today I have a guest with me. This is my daughter, Caitlin. She's a 7th grader, and so I thought it would be a great educational experience for her to come watch you guys. So thank you for indulging me in that.
Thank you. So today right now we're going to do Unit 5, Question 3. So I'll read the question and then invite you to start. What is the relationship between the right to trial by jury, natural rights philosophy, and the principle of limited government? Evaluate the criteria for a fair trial as set forth in the 6th Amendment. What is the importance of the right to counsel, particularly in the adversary system of justice? You may begin.
During the Boston Massacre, British troops fired into a disgruntled mob of colonists. Despite public outrage, the colonists granted the soldiers a trial by jury, a right that would be later incorporated into the 6th Amendment and Article 3 of the Constitution, because they felt this right was essential to their views about human liberty and limited government. The jury, not the government, holds the power to determine the fate of the accused, ultimately holding his natural rights to life, liberty, and property in their hands. The jurors bear the responsibility of the verdict, preventing the government from acting dictatorially.
In addition to protecting the right to trial by jury, the 6th Amendment also protects the right to speedy and public trial, an impartial jury, and the systems of counsel, which are designed to guarantee a fair trial. However, these provisions don't always succeed in doing so.
For example, speedy trials prevent delay between indictment and trial. When trials are delayed, witnesses can forget events and evidence can be lost. Moreover, a criminal defendant who is unable to post bail loses his liberty while the criminal charges are pending. Thus, in Barker v. Wingo, Willie Barker had to wait 5 years in prison before his trial occurred, which impeded his liberty and most likely affected witnesses' memories. On the other hand, trials can be too speedy, which gives little time for the defendant to adequately formulate his argument. In Cuba, for example, Jose Medina, journalist, was tried 4 hours after his arrest and sentenced to 4 years in prison.
While trials can be too speedy, they can also be too public. In Shepard v. Maxwell, the defendant was granted a new trial when, in his first trial, the names and addresses of the jurors were released to local newspapers, and in the days that followed, the jurors received anonymous letters and telephone calls, which could have compromised their impartiality, as any verdict that didn't concur with public opinion could have resulted in physical harm. Although Shepard's rights were in peril in that particular case, public trials are essential to the principle of limited government, as it allows the people to be a check on an overreaching government.
In addition to a speedy and public trial, the 6th Amendment also guarantees an impartial jury. In Basson v. Kentucky, the Supreme Court declared the prosecutor's use of peremptory challenge unconstitutional when he eliminated all black jurors. The court ruled that this violated Basson's right to an impartial jury, as the prosecutor had no arguments to justify his actions.
These criteria assist the defendant greatly, but they do not mean much without a lawyer. In Gideon v. Wainwright, the U.S. Supreme Court ruled that even the intelligent and educated layman has little and sometimes no skill in the science of law. Without a lawyer, he faces the danger of conviction because he doesn't know how to establish his innocence.
Miranda v. Arizona further demonstrated the importance of counsel in an adversary system. There, the defendant was interrogated without a lawyer present, and in the opinion of the court, was not given a full and effective warning of his right at the outset of the interrogation process. The Supreme Court in Miranda established that when a person is placed under arrest, he must be clearly informed that he has the right to consult with a lawyer and have the lawyer with him during interrogations. Without the presence of a lawyer, the environment interrogators create can compel the defendant to incriminate himself, which itself would violate the 5th Amendment as well as the natural right to liberty.
Although counsel is monumentally important in the adversary system of law, in the inquisitorial system, attorneys aren't nearly as important. In the inquisitorial system of law, the judge supervises the gathering of evidence, acting as the detective. The judge also determines the outcome of the case. Attorneys in the inquisitorial system are much more passive. Their sole job is recommending questioning to the judge, and in some countries, questioning witnesses only after the judge has finished. We are now ready to take your questions.
So you guys spoke about the importance of an impartial jury. Some observers might argue that in high-profile cases, the criminal defendants actually face 2 trials, one by a jury and one by the media. Can you please talk a little bit about whether or not you agree or disagree with that statement, and what evidence you can offer to support your answer?
Can you repeat the question?
So what I'm interested in hearing is you guys have spoken about the importance of an impartial jury. And in high-profile cases, the media coverage is pretty extensive. So some people argue that a defendant in that case faces a trial by jury, also a trial by media. Do you agree or disagree? And can you provide some evidence to support your answer?
I would agree with that statement because, such as in the case of in the trial of Zimmerman in Florida, the attorney, Zimmerman's attorney sought to close the trial from the public by the use of not allowing cameras to be pointed at the jurors and to keep the court proceedings secret until after the trial finished, and also to keep cameras out of the court or out of the halls of the courthouse just to keep the jury impartial, and also the jurors were sequestered after they had been chosen, so they had no media attention to keep them impartial. And this keeps the jury, impartial and out of the media's view, so they can not be influenced by public opinion and give a proper jury trial to Zimmerman.
A similar case would be the Shepard versus Maxwell, where he too had a very great public exposures like Zimmerman, and so he too requested an impartial jury, and to that the court also agreed that since the public, the media would obviously affect the juries in their bias in actually deciding, because the newspaper were also criticizing Shepard as the guy who had affairs with all women. They were all negatively criticizing him as the guilty one. So therefore, the court decided that, yes, Shepard, to have a fair trial with an impartial jury, they had to close the trial.
Moving on to the next question. This kind of draws on the media idea, but the Sixth Amendment requires the trials be conducted in the state and district in which the crime was committed. What are the reasons for this requirement, and when and why can exceptions be made?
Well, for one, keeping it in the same district is necessary, so that a person on trial is being judged by the members of his community. As when the jury is being made, they select random people from the community where the trial or the crime was supposed to be committed. So he's being represented and judged by the members of his community.
However, there are instances in which high-profile cases, or maybe not as high-profile, the impartiality of the jury can be compromised, and therefore the trial can be moved to a different county or a different district in order to ensure that the defendant receive a fair trial.
Do you have any examples of that happening?
Not specifically.
Actually, I think I'm not for that too. So, in Colorado, we have that James Holm case is currently going on, and as almost everybody in the audience would know, you guys know him. We know his crime, we know his profile, we all know his characteristic. But however, if there is actually a place in the country where the populace is not as aware of his information or perhaps the crime, then it would be that to guarantee Holmes a fair trial, that we move the case to that area to guarantee unbiased decision with the juries when it's being made when they selected, as Zach mentioned.
Okay. The Sixth Amendment guarantees a fair trial. The First Amendment affords the press and the public the right to attend criminal trials. In what ways do these rights, the rights of the press versus the right of the public to attend the trials, conflict with one another, and why?
So, with the importance of the First Amendment in Richmond newspaper versus Virginia, the Supreme Court ruled that even though the defendant requested that let's close the trial, there's too much media attention to have a fair trial, we need to close it. However, the Supreme Court ruled that since it is the First Amendment, the press's right to report freely, and this itself connects to the concept of limited government in that if the press can report on these trials and let the public know about this itself will be a check and balances to let the public know the judiciary process going on with this. This is how we're doing it, this is what the verdict we did, therefore the public's aware and perhaps in possible corruptions can correct them by the public.
So that being said, knowing that the press is heavily covering and following the James Holmes trial, do you think you can get a fair trial in Arapahoe County?
Personally, no. I think it's very unlikely that Holmes will receive a fair trial in Arapahoe County, especially because it is so broadcast the whole state and to the entire nation. So for Holmes to receive a fair trial, personally, I believe it would be best for him to be moved to a different county.
Also, in the Denver Post newspaper we just read right now, the Holmes, the lawyers were requesting that in the court's website they request that can we take out the information about Holmes' cases to make a fair trial. But however, they already mentioned that we already suppress enough information to provide a fair trial, and that itself again violate the First Amendment, the press's right to access information of the trial. So therefore, they denied his request.
Do you guys have any further comments or how we do this?
Time.
Wonderful.